Your audio is.
Since we're live. Good morning, I'm Cheryl Mercedes, an investigative reporter here at KHOU. Thank you so much for joining us. Today we have Sarah Gertis with us. She is an HOA attorney, and there's a reason she's here. Good morning, Sarah.
Good morning. Thank you for having me.
Okay, we aired a story last night that I had been working on for, I'd say, about 3 months. Did a lot of digging and trying to track down the source of this. It's HOA. And if you have a home and you live in a subdivision, you probably have to pay an HOA fee or dues either once a month or once a year. But do you know where that money is going? Well, a lot of folks would say, yes, it goes to restore the lake or pick up litter. There are rules that need to be enforced, and sometimes there's even a community pool. But sometimes those kind of things are not maintained, and then you start questioning where the money is going, which is what we had in this situation. Now, Sarah, you are an HOA attorney. Before we watch this story, because we're going to show it to you here shortly, why do HOA attorneys exist?
Great question. So the practice of law is very vast, and the practice of homeowners association law is very specific. There's a specific portion of the Texas Property Code that pertains to the rights for homeowners and for homeowners associations. So there are really a handful of firms in the Houston and surrounding areas that truly focus on practicing homeowners association law.
Okay.
It's important to properly represent your clients, to have the knowledge necessary to properly advise the board.
Okay, so what's different from an HOA attorney and an HOA management company?
Great question. Generally, HOAs are nonprofit corporations, and they are run by the board of directors. That board will hire a management company that comes in to assist with the day-to-day duties, collecting assessments, calculating the financials, providing financial records, and driving through the subdivision to cite violations. That particular corporation, the association, will also have an attorney that they will look to when you have questions regarding whether or not a particular restriction is enforceable, when homeowners refuse to pay their assessments, and when homeowners refuse to come into compliance with the restrictions. So as an HOA attorney, we are there to assist the board when necessary. The board of directors is always the HOA attorney's client. The management company is simply the go-between.
How long have you been doing this?
I've been doing this for just over 10 years.
Okay. When we brought this case to you to look over, what were your thoughts?
I was shocked, honestly shocked, for homeowners to pay assessments over that period of time and to see little to no return. They are not unable to obtain a copy of their financials. They don't have anybody holding meetings, regulating their subdivision. It's just simply shocking. Okay.
Now, we want you to go ahead and submit your questions, because we only covered so much in this story, but we know that you may have some questions that are particular or specific to your neighborhood. So we're going to go ahead and let you watch this story and get your questions ready, and we are going to be looking at them, and then Sarah is going to help answer those questions.
Yes.
Okay, let's take a look. It's a subdivision called Inwood Village. There are 450 homes,
And then I looked.
and these ladies remember a time they call the good old days.
We had security and we had yard of the month.
Yes, I remember Yard of the Month.
Only they have not enjoyed those things in over a decade. The neighborhood swimming pool has been closed for at least 10 years, and
Yards are supposed to be maintained.
And heavy trash stay out there for weeks.
they can forget complaining to the HOA board. When's the last time you had a homeowners association meeting?
I would guess at least 10 years.
Over 10.
About 10 years.
But they are still paying dues.
I paid $240 this year.
$250.
I didn't pay.
$275.
The HOA is managed by Tejas Capital Management. According to Secretary of State records, that company is run by Ronald Cochran. Andrea James showed us copies of the checks she wrote to the HOA the last 2 years. One for $240, another for $275. Each deposited into different accounts.
I was stupefied. I could not believe that.
When we checked the status of the Inwood Village HOA, we discovered it was involuntarily dissolved in July of 2007.
2007?
Yes, ma'am.
Wow.
We went to the address listed for Tejas Capital Management, but we found no such company. We went to the head of the company's house more than once, but no one came to the door. And he hasn't returned our calls either. I'm calling to speak with Ronald Cochran. We wanted to report it to a government agency, but in Texas, there is not a specific agency that regulates HOAs. The Secretary of State's office recommends that people with issues talk to a lawyer. So we talked to HOA attorney Sarah Gertis.
Based upon the records that I've seen to date, there's no longer a board serving the community.
Have you ever seen anything this extreme when it comes to homeowners associations?
I have not seen anything this extreme, no.
How serious is this?
It appears it could be quite serious with a subdivision of this size of over 400 lots.
Gertis suggests the homeowners do the following: request the financial records, create a new board of directors, then hire a new management team.
The fact that these checks have been deposited in different accounts throughout the years is very concerning.
Inwood Village.
The homeowners have sent a certified letter to Cochran requesting the financial records for the HOA.
We would greatly appreciate your prompt response.
Cochran has 10 days to get back to them. If he doesn't, they could take him to court. The homeowners tell me they complained to police. The Houston Police Department would not confirm whether they're investigating. Cheryl Mercedes, KHOU 11 investigates. Cue us, please. So, Sarah, you saw the story.
Yes.
What'd you think?
It was great.
Okay, so we covered a lot of the bases there, but you know, a simple question some people have is, why do you even need an HOA?
That is a fantastic question. And an HOA serves several purposes for a subdivision, but it truly protects your property values. First and foremost, by enforcing the restrictions, you protect the property values for your own home and for your neighboring proproperties. As a homeowner, that's what you want. You want your property value to go up. You don't want to be living next door to a junkyard or, unfortunately, to someone that's decided to paint their house pink, and an HOA helps to prevent that. For larger subdivisions as well, you have amenities. You have your pool, you have your landscaping, you have your entrance sign, you have your walking trails.
Now let's take a look at that pool. You remembered,
Yes.
you didn't see it until you saw the story last night, right?
Correct. That pool was
10 years?
that looked horrible. I can't imagine the amount of money it's going to take to get that pool up and running again. But that's for the purpose of paying assessments. Those assessments are collected to maintain and take care of your amenities, and it's clear in this particular case that someone's holding the money and not using it to keep up the amenities for the community.
Someone's asking us, why do they need permission from an HOA to have a trampoline in their own yard?
Yeah, great question. So every subdivision is a little bit different. You have a set of restrictions that pertain to your community, but for a majority of the single-family HOA communities, there's a restriction that prohibits you from making alterations or putting up structures in your backyard without HOA's permission. So it goes to sometimes to the little items like trampolines, to constructing sheds.
Flags even.
Flags, baseball cages. We've seen zip lines in the backyard. So it may be a small change to you, but from a community standpoint, it's important to get your HOA's permission.
Okay, perhaps some of you have been through this, but if you do violate any of the rules, you break the rules, you have to pay a fine. Who establishes those fines, and what happens if you don't pay them?
Yeah, great question. So some associations will fine, and others will simply send demand letters and request that you come into compliance. The fine is used as a deterrent to sort of force a homeowner to come in compliance with the restrictions. The board of directors for your community will set the fine amount, and you have, as a homeowner, if you are being fined, you have the opportunity to go meet with your board, contest the fine, discuss the violation before that fine is actually levied.
Okay. Another question here is, what kind of measures can a community take to make the HOA fix a playground and a splash pad in the area that the community lives in?
Right, so there are certain measures that homeowners can take, but what the homeowners need to do is they need to attend board meetings, they need to express their concerns. They need to, really it's the community coming to the board saying you're collecting our money, we would like it to be expended for this particular project. And if you have questions about where your financials are, where the association's money is being spent, then you need to request those financials and review them.
Okay, we're going to get to that in just a moment so you can elaborate on how you go about doing that. But what about, there is a hotline that you told us about, correct? We're going to get that up on the screen here in a second. The hotline. Someone's asking, what if we feel our HOA is inadequate?
So great question. The questions like those are where I would call the hotline. The hotline is not run by attorneys. It's run by managers who are, essentially, they are licensed. They are knowledgeable in this field. They are educated. And they will help you to determine whether or not your concern is valid, whether it's something that you need to pursue with the association, or whether or not something that you need to take up with an attorney.
Okay. Someone's asking, can an HOA have its own security without a state PSB license with its own patrol?
Great question. So in many HOAs, they don't provide security or safety. They're there to enforce the restrictions and collect the assessments. As an HOA, what I would expect is for the board of directors to go out and solicit contracts for security and to retain a third-party company to bring that security on site.
Okay, so there are some things, if an HOA is in a bind, kind of like this one, or it doesn't exist, that homeowners can do. You did mention request those financial records. How does someone do that?
Great question. Under Section 209 of the Texas Property Code, it's really the Homeowners Rights Act. There's a provision under which you can submit a letter, certified letter, to the management company and or the board of directors, or in the case of Inwood Forest, the manager, to request the records of the association. Pursuant to the law, the manager and or association is required to turn those records over. If they do not, there are penalties which may be enforced, which is recovery of attorney's fees, recovery of costs, and a court order requiring the association to turn over those records.
What's a good next step?
So if the records, in this particular case that we're dealing with, if records are not produced and you're dealing with a defunct homeowners association, the next step in this particular process would be to call an annual meeting of the homeowners, to elect a new board, and then to reinstitute the corporate standing of the association. At that point, you have a board, you have an operational homeowners association, you need to collect assessments which have not been paid, to collect funds for the community, and pursue that manager who's likely holding your years, 10 plus years of assessments which have been collected.
Okay, now in this case, these homeowners, some of them are paying their HOA fees. We spoke to one lady, which she is not in the story, but she went to close on her home and boom, there it was, $3,700 on her closing documents to be able to complete the sale. How can an HOA that is defunct go after a homeowner like that?
Great question. From a title company standpoint, you have to clear all liens against the property to provide a title commitment. So in this particular case, every lien, the mortgage, the HOA lien, because your assessments are a lien against the property, it must be paid. So the title company reached out to the manager, Mr. Cochran. He provided a payoff, and that amount of money was paid, which is required to give the buyer clear title. And so there's provisions in our Texas Property Code wherein an HOA is required to provide documentation in the real property records that states who title companies need to contact for payment. So from that homeowner standpoint, they needed to pay that money to provide clear title. Unfortunately,
it's a lot of money.
Correct. That money should not have been paid to Mr. Cochran, which is why they need to form a new homeowners association to start collecting assessments.
So should people who live in Inwood Village continue to pay their dues and send it to that P.O. box in Spring, Texas?
Usually, in 99% of situations, I would say yes, continue to pay your dues. In this specific case, I would urge homeowners to hold off on paying your assessments until the annual meeting is held and to pay your assessments to the new board.
How easy is it to get rid of this management company and establish a new board and hire someone else to take care of those finances?
Thanks to the Texas Property Code, it's very easy. Every HOA is required to have one annual meeting a year. This HOA has not had an annual meeting in the last 10 years. So a group of homeowners that I am working with and that I'm assisting are going to call this annual meeting to elect directors.
Okay. So at this point, the ladies in the story have told me they sent the certified letter. We were there with them when they wrote it. 10 days to respond. Time is up. What happens now?
Well, the ladies, they could pursue one of two options. One, they could initially sue Mr. Cochran to demand turnover of those records. However, the best option for this community is to form the homeowners association and then for that HOA to go after Mr. Cochran. And it is possible to reinstitute a corporation that's now defunct with the state of Texas because it is their HOA. The key is holding that annual meeting and getting a board in charge that they have the authority to represent the community and they would be the ones to pursue him.
How likely is it that they'll ever get their money back?
That's a great question. It's very hard for me to determine, especially based upon the lack of response from Mr. Cochran. I suspect that some form of litigation is going to be necessary to force Mr. Cochran to turn over financials and turn over that money.
Okay, so they have a right to those financials. They have not gotten them, so
Yes.
they'll probably have to hire an attorney.
Yes.
That can get expensive.
Yes. And so that's, I mean, our firm is helping pro bono right now to call the annual meeting, get the board up and
Oh,
going.
that's great news.
And then when 2020 rolls around, they'll collect assessments from everyone in the community. So they should have some funds to go after Mr. Cochran. And you know, this type of situation, they may want to contact the local police as well, simply because this could be embezzlement. We're not sure. Still in the initial investigation. But if Mr. Cochran refuses to turn over that money, those are not his funds. Those are the funds of the community, of which he has no right to.
You know, the first thing that got our attention was the different amounts that homeowners were paying in this one neighborhood. Is it typical for everyone to pay?
Absolutely not. Every homeowner should be paying the exact same amount, at least in the subdivision, for every single lot. The fact that discounts were being given tells me that he was probably trying to get homeowners just to pay whatever they would pay.
Okay. Reading this question here. Okay, we've got someone here with a leaky roof in a bedroom and contacted the roofer to fix it. The roofer informed him he needed a new one because it was leaking, and I told him to go ahead and replace it. And then got a letter saying that they were supposed to talk to them first, and they were threatening to get an attorney because they replaced it without an HOA okay.
So in that particular situation, you definitely want to submit an application. We call it an application for architectural approval or architectural control. Submit the application even though you have done the work and try to obtain the board's approval. There's some changes in the law in 1994. The failure to obtain the HOA's approval is not a violation per se. If you repaired your roof and it is in compliance with the restrictions, you simply just need to get their approval after the fact. However, if you put shingles on your roof which are not approved by your HOA, then that is another problem because you have an ongoing violation.
I mean, I wouldn't think of that.
No.
You know, like this HOA does not allow architectural shingles. I would not have thought of something like that.
Really, I mean, borderline any exterior change you're doing to your property which is noticeable, you definitely want to reach out to usually the management company to determine whether or not you need the association's approval. It's better to have the approval up front than to go through this situation where you've already done the change, you've already made the alteration, and go seek the approval after.
Because at this point I would think, okay, I need permits from the city if I'm doing a big project that's over a certain amount to my home, but you know, getting approval from the HOA, unless that roof was going to be pink, I wouldn't think that that's something that you needed.
It's definitely something that you need in a majority of subdivisions because you'll see every once in a while somebody will come along that thinks that it is okay to put up pink shingles, and just stop the person who's putting up pink shingles requires everyone in the subdivision to request and obtain approval for a roofing change.
Okay, I've got someone here saying the HOA tried to make me change the color of my front door when I bought it that way.
That's a completely different situation. A homeowners association only has 4 years to enforce a violation of the restrictions. So if that front door was a violation, the new owner would need to determine A, whether the prior owner requests and obtain permission for that door, and B, how long that door has been there.
Okay.
I will say as an owner, you buy subject to whatever violations are at the property. However, the purpose of a management company, when you buy a property, you get a resale certificate that says whether or not there's known violations of the property and also what assessments are owed. So as a buyer, that's how you protect yourself.
And why is code enforcement necessary in these neighborhoods? Is it just because people don't like a color or don't like to see trash for a certain amount? Why are they necessary?
I mean, great question. It's all about protecting your property value. So you have your one set of restrictions, which is really the contract between the HOA and the homeowner, and the board of directors has to enforce it against everyone evenly. So small variation of the property, large violation, it has to be enforced. But the purpose of those restrictions is to protect your property value. What may be, some garbage, a small portion of garbage on the front yard for one lot, maybe somebody's cleared out their house and hasn't removed their garbage for a month on another lot. So you have to enforce them uniformly to truly protect property values.
Should I send my HOA a late fee for cashing my check 4 months later? We know there are late fees if you don't pay your dues on time.
I mean, if the association is seeking that late fee, I would recommend paying so you don't continue to show a delinquent balance, and then go to the next board meeting or go to the management company and ask why the check was deposited late. Provide proof that you paid on time, and that late fee should be reimbursed or waived.
Okay. So at this point, we were unable to find Ronald Cochran, whose name is tied to all of this. Sometimes when the residents call, they say they are able to reach him, but yet he won't turn over the records. Any idea from what you've seen what might be going on? I mean, he's got 2 different accounts at least that he's depositing the money into. We've gone to the address that's listed for him. It doesn't appear that he's living a life of luxury.
Unfortunately, there's not a lot of information to go on, but I suspect that he's simply depositing that money. He may or may not be using it for personal use. The fact that there's 2 separate bank accounts or more that assessments have been deposited in is a red flag. As an HOA, like I said, it's a corporation, so they have a corporate bank account within which all of their assessments are deposited. There's no reason that there should be 2 accounts. And also because he's hiding out, he's not responding to anyone, I suspect he's probably misused those funds.
So, you know, you mentioned HOA meetings. A lot of people are like, oh, a meeting, I don't want to go to another meeting. But today you raised some great questions, or these folks have, as to why they should absolutely attend all of their meetings, especially with questions like these about enforcement.
Absolutely, and a majority of the meetings for the board, they are open to homeowners, and if you sign up to receive email notifications from your HOA, you will receive notice of when those board meetings are.
And is there a minimum that they should have each year, you mentioned?
I would say most of those associations have meetings at least quarterly. Many have them for larger subdivisions, have them every month, every other month. There's no set requirement. That's something that would be in the restrictions for the community. But at a minimum, I mean, take a 450 lot subdivision, I would expect monthly, if not every other month.
So when the rules change, it has to go to a vote, correct? Tell me how that process works. We have someone here saying my fence doesn't match my neighbor's fence. It was okay 15 years ago. Why the change?
So that's actually an issue that you probably consider calling the HOA hotline for.
Okay.
You have, there's different documents that an HOA has. It's the declaration, which requires a vote of the membership to change. But some communities, the board has the right to adopt rules, to adopt guidelines outside of the restrictions. So those would not require the approval of the membership. However, those are items that would have to be discussed and voted on at a board meeting, which is again why it's key to see what your board is voting on, see what the agenda looks like, and see if you want to attend those board meetings to raise questions and concerns.
What does it take to make a change?
At a minimum, you're looking at a 67% to change the restrictions for the community. So if you want to make a big change, you need to get 67% of the homeowners involved and to vote in favor of it.
Now, should HOAs send out a letter ahead of time? And what's that time frame to let everyone paying dues know there's a meeting?
So for board meetings, this is more or less what the state law says is you have to post it online somewhere, like a community website, or post it in the community, which would be in the pool at the clubhouse. And you have to email notice of a board meeting out to the homeowners that have submitted their email address to receive notice. And that's just for board meetings. However, for an annual meeting or for a meeting at which you're going to vote on revising the restrictions that homeowners get to vote, they're entitled to 10 to 60 days notice.
And these homeowners say they haven't even seen a book of policies or any rules, a list, anything anywhere telling them what's allowed, what's not allowed. Is that something that they should get when they move into the neighborhood?
Correct. As a part of it, closing through a title company, the title company and or the seller should provide these homeowners with a copy of the restrictions for their property so they know what the rules and regulations are when they buy into it. In addition, this association has been operational for about 10 years, but there's changes to the Texas Property Code during the last 5 to 10 years wherein associations are required to record all of their documents in the real property records. They're also required to file a management certificate that references the restrictions. So in the usual standpoint, I would say if you have questions regarding what documents govern your community, you just need to reach out to your manager, ask your manager for a set of those documents, and the manager will provide those.
Okay. Is there anything that you wanted to add maybe to let our viewers know that I haven't asked or they haven't asked yet while I kind of look through here and see if there are any more questions?
Yeah, certainly. From a homeowner standpoint, if you have questions about what your HOA is doing, about why they're sending you letters, definitely do not hesitate to reach out to management or to attend a board meeting and raise your questions. I mean, many homeowners feel that they are being wronged when they're being pursued by the HOA, or they're upset about it, and as a result, they refuse to reach out to the board or management. I will say, 95, 96% of HOA disputes can simply be resolved by sitting down and meeting with your board.
Okay, and that number again, we'll put that up on your screen so that you can call the HOA hotline if you have any questions, because like you said, sometimes they can answer and they can help, and you don't necessarily need to hire an attorney.
Correct. And this HOA hotline is manned by managers who are educated in this field. So they provide their time free of charge to advise you whether or not you have a serious issue that requires legal intervention or whether you just need to attend a board meeting and raise your concerns.
And you mentioned, when I spoke to you, you said HOA attorney. I'm like, HOA attorney, those exist and people need those. You said 9 times out of 10 subdivisions do have one.
Yes. Yes, I mean, so for an HOA attorney, we're really using it as needed basis. I have some clients that come to me once a year. I have some that come to me once a week. But if you have a legal inquiry, HOAs are a corporation. They're a nonprofit corporation. You need to reach out to your corporate counsel to obtain information to properly guide the board on making proper decisions.
Okay, are there any more questions that we have on any other devices that people have asked?
Linda just asked about raising the dues without a vote of the community.
Yeah, it's a great question. Your restrictions are specific to every subdivision.
So we're talking about raising dues,
Correct.
is to make sure folks can hear.
Yes.
Someone's asking about, do they need a vote to do that?
Great question. So the deed restrictions are specific to every community, so you want to check your deed restrictions. I'm just going to say, commonly, the board has the right to increase the assessments 5 to 10% without membership approval, and anything above that would require membership approval. However, you definitely want to check your restrictions.
Okay, and that should all be written and
Yes.
documented.
Documented and recorded in the real property records.
Okay. Is there anything else that you all see? We have our crew behind the scenes working to feed us your questions. We have one platform open. We know that we are on a few right now where you may be asking questions. No? Okay, thank you so much for joining us, Sarah Gerdes. We appreciate
Thank
you
you for
joining us
having
this
me.
morning. And we look forward to following up with you on what's next for Inwood Forest.
Yes.
And what will happen with Mr. Cochran and what's next, because I know these homeowners are desperate and they thought they were paying different amounts, and it turns out this is a bigger deal than they could have ever imagined.
Yes,
So-
and we'll definitely keep you up to date.
all right. Thank you so much for joining us. Keep your questions coming in. We'll have all of this posted online as well as the HOA hotline number. So if you missed it here, you can go online. You all have a great day, and thanks so much for joining us.